Hi, everybody. I'm Lisa Bloom.
I'm Sarah Bloom, and today we're going to talk about, was my layoff illegal? So I'm going to talk today about what laws your employer has to comply with if you're laid off and when you might have a potential case from a layoff.
So it's a terrible time for everybody for layoffs. We've been hearing these numbers. It's hard to even get your brain around them. What are the statistics?
So as of the time we're making this video, there have been 26 million claims for unemployment, and that's just been in the last 6 weeks. And those are just the people that can get through to actually file. Many people have not been able to get through, government bureaucracy. So those numbers are actually much higher. So this is a subject that's on most people's minds right now. I think if you're lucky enough to not have had your work affected by the coronavirus, you know someone close to you who has experienced a reduction in their work or has been laid off. So businesses have really been hit hard from the virus, but they still have to follow the law.
Yes, the law is still in place.
Still in effect.
What types of things are illegal in a layoff, Sarah?
So first, a lot of employers have to give employees notice of a layoff, and that's up to 60 days notice. And that's because of the WARN Act, the Workers Adjustment and Retraining Notification Act. You can remember it like you have to warn people, WARN, the WARN Act. And that requires employers who meet certain factors to give employees 60 days notice before a mass layoff. So the purpose of the act was to provide workers and employees some transition time to find a new job and to ease some of the personal and financial difficulties that are caused by a layoff. Many states have their own WARN Act laws, and states like California, where we practice, have laws that are more employee friendly. But today I'm going to talk about the federal WARN Act, the WARN Act law.
Okay, so this WARN Act, when do employers have to comply with it and warn employees that there's going to be a layoff?
So employers that have at least 100 full-time employees are covered by the WARN Act. And the types of events that are covered by the WARN Act are plant closings or mass layoffs at a single site of employment. So if the above are met, your employer must give you notice. If you are terminated, not for cause, laid off for more than 6 months, or your regular hours of work are reduced by more than half during a 6-month period. So that all means, in other words, we're talking about big employers who have to give you a few months notice if you're laid off. So
only fair.
Yeah. So if what I just talked about is true, your employer must give you 60 days notice in writing before the layoff, and the notice itself must contain certain things like whether the layoff is permanent or temporary and the date of the layoff. So a verbal announcement does not cut it here under the WARN Act. And if your employer violates the WARN Act, they can owe you up to 60 days of pay, depending on how much notice they give you.
So even now, in the time of coronavirus and this crisis that has fallen on so many of us, employers are still obligated to give people 60 days notice before they lay off?
So there are exceptions to the 60-day notice period, and one of them is unforeseen business circumstances. Coronavirus certainly is an unforeseen business circumstance. In fact, California's governor has said that if California employers are doing layoffs because of the coronavirus, they do not have to comply with the 60-day requirement. But, and this is a big but, the employer still has to give as much notice as is practicable. So in other words, they still have to do the best they can. And they must also provide a brief statement as to why they cannot give the full 60 days notice. So this does not mean the employers can give no notice. It means they only may be required to provide a reduced notice, a reduced amount of time other than the 60 days, and still be on the lookout for that written statement as to why they're not giving the full 60 days notice. So this was just a broad overview of the WARN Act. There are actually a lot of technicalities that I did not get into. So if you think your company did not follow the WARN Act, you should contact a lawyer immediately.
Okay, so what about mixed cases? If the employee was harassed or discriminated against and then is laid off, is there a potential claim there?
Yes, so we regularly have these cases where an employer has a layoff and conveniently adds in an employee that has just complained about sexual harassment or discrimination. And courts have held that if an employer is using a layoff as an excuse for an improper termination, it can still be considered retaliation, and retaliation is illegal. So if you are laid off and you have been discriminated against, especially if you just had a recent complaint to Human Resources, you should contact a lawyer. So in conclusion, if you're laid off during the coronavirus, make sure your employer follow the law because you still have rights. If you think your rights were violated, you should contact an employment lawyer like the Bloom firm immediately.
Yes, stand up for your rights. We're getting a lot of calls about these types of cases right now, and we're happy to talk to you for free and confidentially and advise you of what your rights are. So thank you, Sarah, for walking us through that. And until next time, stay strong and stay safe, everybody.
Thanks, everyone.